The Colorado 1910 Young v. People decision says that you can use force at perceived danger. That's Henry Young. That's Henry Young killed Charlie Wilkinson. Charlie Wilkinson, who was a police officer, and who knows what the hell happened with that. But that damn family, Henry Young's family, Bart Young and all those other Youngs, they were notoriously evil, wicked people. But his name is part of a Supreme Court case. 1910 Young decision says you can use force at perceived danger. The Colorado 1888 Bush v. People decision says that you cannot murder an aggressor immediately. So if a person is just trespassing, but it doesn't look like they're going to commit any crimes, you can't just shoot and kill that person. You can, resist, you can remonstrate, but you can't just straight up, So People v. Williams also says the same thing that Bush v. People said, 1888 Bush decision. You can't just murder an aggressor immediately. You can't just kill a trespasser. You can't just kill a trespasser. Now this is about People v. Olguin. The People v. Olguin decision is 1974. 1974 was way back in, before the 1980s. You got Vigil v. People, Schiffner v. People. So the citizen's arrest law in Colorado is 16.3201. A person who is not a peace officer may arrest another person when any crime has been or is being committed by the arrested person in the presence of the person making the arrest. So any person can arrest any other person for committing any fucking crime in goddamn Colorado. So if you're in Colorado, it doesn't even matter if you're a citizen, if you're a person. So if you're a person and you're in Colorado, first of all, don't rob, rape, hit, kill, abuse, bear false witness, torture, arson, kidnap, or enslave. Don't you go around committing crimes. But if you're in Colorado and you see other people committing crimes, if you come to visit Colorado and you see people robbing or raping or hitting or killing or, jabbing, dragging, grabbing, bagging, or stabbing, you can arrest that person. You can arrest that person because of the citizen's arrest law. Any person in Colorado can arrest any other person in Colorado if they're committing a crime, if they witnessed that person committing a crime, or they witness elements or acts that make it look like a crime is being committed. Now that's interesting. That's a little bit different than being, perceiving a threat that's not there. What that's saying is, with this case, well, let's get into it, right? Let's just get into it, Let's just get into it. With the People v. Olguin case, even security guards can arrest folks. Even security guards. So the citizen's arrest law goes ahead and extends police powers to when they're off duty and out of their jurisdiction, right? A cop in Saguache County can arrest anybody in all 64 counties in Colorado. Why? Even though he's only supposed to have police power in Saguache County? Because of citizen's arrest. A citizen, you don't even have to be a police officer. Anybody can arrest another person for any crime. Person A can arrest person B. If person B committed a crime that person A had witnessed, or saw elements of. That's what Olguin is. So Roseanne Olguin, Olguin, Olguin. 1974 Olguin decision. So this is Roseanne Olguin. Roseanne Olguin, she's sitting there, in Denver General Hospital with somebody else, and you had two security guards, hospital security guards, who stops Roseanne Olguin. And even though they technically didn't see Roseanne Olguin take the typewriter, she also had a telephone intercom system. So she had just some electronic equipment tucked underneath her coat, underneath her jacket. And they said, "Hey, what's under your coat?" And then she just played dumb and said, "What?" And never said anything. They later on said, "Oh, we could see a little corner of the typewriter." So, they did witness, a robbery in progress. Technically, they witnessed the robbery in progress. Of course, they had a right to arrest her. Of course they did. But just in case, the Colorado Supreme Court says that you can arrest a person if you saw them commit the crime, or if you see them in, progress, or if you see elements that indicate that a crime was occurring. So two suspicious ass people that had shit underneath their jacket, you can arrest that person. Now, if it turns out that they're just, overweight, or if they just, put on 5 layers of clothing that day and they didn't take jack shit and you're in the wrong, well, you'll have to apologize. But I'm going to say that there's probably some civil liability shield. But you're allowed to arrest a person if you see the crime in your presence, right? If you witness the crime, if you see it, if you hear the crime, you can make the arrest. Or if you saw elements that indicated that a crime was occurring. So if you see acts that seem like a crime is occurring. It turned out that the security guards were correct. They were, they had suspicions, but apparently they didn't know the extent of their powers. They told, the two suspicious people to just sit there while they called the police. The police showed up and then they arrested. And then later on, their lawyers, apparently Roseanne Olguin had a fantastic lawyer, because they're going to say, hey, even if I'm stealing a typewriter and intercom telephone equipment, even if I am stealing shit out of the Denver General Hospital in broad daylight, you're just a damn security guard. You can't arrest me, and those cops didn't witness a damn thing. They didn't see shit. You're a security guard. You ain't shit. They ain't shit. So what? Anybody could just steal fucking shit? Fuck you. I'm okay with this arrest. I'm okay with the security guards arresting the person, and the police definitely. What the fuck? The police are supposed to show up to the scene and not arrest them? So basically, nobody knew what the hell to do. The police, that's their thing, right? A security guard, I could understand them saying, well, shit, am I allowed to, how far am I allowed to, how much police power do I have? So again, the People v. Olguin, the 1974 People v. Olguin decision is important, because you could say that you saw the crime, or you saw elements that a crime was occurring. I can use the example of Ahmaud Arbery. They want to say that they suspected that he was committing a crime. Were there elements that a crime was being committed? Possibly. Perhaps under People v. Olguin 1974, they might have had some defense. Because if you didn't see the actual crime, then what the hell were you even doing? I mean, that's their law or whatever. But if it was here in Colorado, if you saw Ahmaud Arbery actually commit a crime, no doubt about it. No doubt about it. You have a right to arrest him. If you saw Ahmaud Arbery just, say you saw something in his hand and he threw it away, then it was suspicious. You saw something that looked like he committed a crime. But if you just, there's a black man running around and you're just scared of a black man, that's not good enough. You got to see elements that indicate that a crime was occurring. And if you're going to make an arrest, right, that's kind of a, false imprisonment. That's kind of it's big, right? That's an assault. That's to make an arrest. That's you're going to put your hands on that person, and then, put handcuffs on them and detain them and subdue them and sit them down and take them into jail and, get some justice, right? Schiffner v. People. You got a lot of different cases. People v. Joyce. Colorado Appeals 2002 case, People v. Joyce, which says that Colorado 16, the chapter 16 is the operative clause. Schiffner v. People, 1970, People v. Wolf, 1981, People v. Lott, 1979. Vigil v. People. So this is on the power of citizen's arrest. If you're a citizen in Colorado and you see people committing crimes, you can arrest them. In fact, I want you to arrest them. Please arrest them. Fuck these criminal bastards. If the cops aren't doing their damn jobs, then we, the citizens, have to stand up and we need to do their jobs for them. I don't want to live in a fucking neighborhood where the criminals are fucking running rampant. It's bullshit. When you're a poor, person, you got to look over your damn shoulder for the fucking criminal cops and criminal citizens. You got to look over your shoulder for every goddamn person, and it's not fair. And if you're in a rural area, not just in a poor area, but in a rural area, there are no police officers at all. So you have to, stand up and defend yourself, or what? Just let some motherfucker come into your house and take everything you got and just be like, well, didn't know what to do. No, you're not expected to let anybody criminalize you just because a police officer wasn't there. You have tools. If you live in Colorado, you can arrest that person. You have a right to defend yourself. You have a right to arrest that person. You have the power to citizens arrest. And I would say especially for felonies, especially for felons, for rapists and, violence and murder and abuse and stealing and torture and arson and kidnapping and bearing false witness and enslaving others. These are the 10 eternal, this is Johnny Law, the 10 eternal postmodern laws of all time. You can't do that shit. You can't go around doing that shit. So one more time there, people of the universe. You come to Colorado thinking you can kidnap, arson, torture, bear false witness, abuse, kill, hit, rape, rob, jab, drag, grab, bag, or stab. You are mistaken. Every single one of us, all, 8, 9 million Coloradans can arrest the fuck out of you. And if you're in Colorado, it doesn't matter if you're coming from outside or inside. You go around committing crimes against people, we can arrest the fuck out of you. We can arrest you. Not excessive force, but enough reasonable and appropriate force. Right? Isn't that what that second law says? Chapter 18-17077. Yes, sirree, Bob. Yes, sirree, Bob. Norsby v. Jensen, when interpreting two statute sections, we must attempt to harmonize them to give effect to their purposes. And if possible, what? Reconcile them so as to uphold the validity of both. Norsby v. Jensen, Colorado Appeals, 1995. People v. Garcia, COLO App 2002, State v. Neto, COLO 2000. The statutory scheme of a state law must read as a whole and interpreted so as to give consistent, harmonious, and sensible effect to all of its parts. State v. Neto, COLO 2000. People v. Garcia, COLO App 2002. People v. Joyce, People v. Wolf, 1981. People v. Lott, 1979. People v. Olguin, 1974. General Hospital. What? I don't have a typewriter and an intercom telephone underneath my coat. What? So it says other acts. If you witnessed the crime occurred, if you witnessed it occurred, right, you already saw it happen, you can arrest. If you see it occurring, you can arrest. Not will occur. But if you see those acts which seem criminal, that's included in the presence of. If it's sufficiently indicative of a crime in progress or its aftermath, you can arrest that person. If the other acts are sufficiently indicative of a crime in progress. People v. Olguin.